Good day, Crime Talk aficionados. We have a great show for you. First, the Kohberger video mystery continues. The suspected assassin of Charlie Kirk arranged for a peaceful surrender out of fear of, wait for it, getting shot. Supporters for Luigi Mangione are advocating for jury nullification. A search conducted at a Hollywood Hills residence linked to the deceased teen found in musician David's car. A California judge rejects the Menendez's brother petition for a new trial. A teacher's theatrical tantrum, little faux surprise at cuffs for assaulting a preteen pupil. Since everyone is a free speech expert these days, I figured I'd actually explain what free speech covers under the First Amendment and what it does not. Your friends are going to think you are so smart. We have This Day in Legal History. Our quote of the day has to do with free speech, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell so you receive notifications of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you, go to crimetalksearch.com, sign up for that background subscription service today. And you say, Scott, why do I need to do that? I am in a great relationship with my spouse, significant other, or whatever. Well, I understand, but you should maybe go check it out. Maybe they've got a little bit of weird behavior. You're going to find out if they have a bunch of other emails that they don't tell you about. The kind you need to set up all those dating apps and other unseemly websites that you pay for various things. Yes, you're going to find out if those are there. Maybe some phone numbers. Maybe you have some burner phone numbers associated with them. Social media presence as well. Find out if they're on some of those other social media apps other than the big ones, so to speak. Find out what else is on your phone that they don't tell you about. Anyway, you should trust your spouse, but it's always good to trust but verify. And you're going to find out if somebody is married, divorced, they have legal judgments against them, are they on the sex offender registry, and of course, what is their criminal history. So go to crimetalksearch.com. You're going to be happy that you did. We also have another big announcement. Remember the other day I told you that we were working on getting this set up on the website so that we could sell these Crime Talk Keychain bag tags that we gave out at CrimeCon? Well, we have done it. There's a link below. Go to scottreich.com, and up in the upper right-hand corner, there is a little button there to click Buy Merchandise. When you do there, you can get one of these little bad boys, $5 plus shipping. We'll get it to you as quickly as we can, hopefully within a day or two from the time that you take an order. So go check it out. All right. Another quick note. Yesterday, we brought you the story of California Superior Court Judge Jeffrey Ferguson. He faced a maximum of 40 years for killing his wife over an argument where he said the gun just went off. The one that was in his ankle holster. Yeah, he got 35 years. So it's pretty good estimate to say that the 74-year-old judge will probably spend the rest of his life in prison. So I guess the moral of the story there is if you're going to commit crime, do it young so you have a chance of getting out, I guess. I don't know. All right, let's go ahead and get to the docket for Thursday, September 18th, 2025. And first, Bryan Kohberger. That's right, the video investigation continues. So 1 month following the online publication of videos depicting Bryan Kohberger in his Idaho prison cell, the origin of the leak has been, not identified. Now, this incident directly contravenes policies established by the Idaho Department of Corrections, where obviously Kohberger is incarcerated and will be for his next 4 consecutive life sentences. Now, in August, prison authorities committed to conducting an inquiry among correctional personnel at the Idaho Maximum Security Institution to identify those who might be responsible. And, those Idaho officials characterized the leak as an explicit breach of Idaho Department of Correction protocols with potential consequences, including termination of employment or criminal charges for the perpetrator. Anyway, in a statement issued last month, the Department of Corrections emphasized that recording and disseminating security footage constitutes forbidden behavior, and all available legal measures, including prosecution, will be evaluated. The statement further affirmed that the safeguards and the well-being of the staff and the inmates is the agency's foremost concern. Now, initially, the Department of Corrections raised the possibility that the footage could have been fabricated or produced using artificial intelligence. However, internal communications from the Department of Corrections and staff acquired through some various public records requests expressed confidence in its authenticity, noting it appeared to originate from within the correctional facility and underscores the gravity of the situation. And yesterday, the representatives confirmed that the video was verified as genuine, though no individual has been implicated. Their spokesperson stated that despite the circulation of altered or AI-modified variants, the original material is authentic and it violates their guidelines. The inquiry will continue as a key focus, they said. And, well, we'll see how that turns out, right? Anyway, the Idaho State Correctional Institutions, which is located near Kuna, Idaho, encompasses the state's maximum security facility, housing Mr. Bryan Kohberger, who is obviously serving those 4 consecutive life sentences without the possibility of parole for those November 22 homicides. Now, although the Idaho State Police typically manage prison-related investigations, the Department of Corrections is overseeing this matter internally as confirmed by the Idaho State Police. Earlier this month, a spokesperson by the name of Blake Lopez indicated that the probe remains active with no new developments. Just a quick background. Obviously, Kohberger pled guilty in July to the 4 counts of first-degree murder under the plea agreement that spared him from ultimately receiving the death penalty. He received those consecutive life sentences without any eligibility for parole or any type of an appeal. And following Kohberger's July 23rd sentencing at the Ada County Courthouse there in Boise, Kohberger was relocated from the county jail to the maximum security prison. Now, records do indicate he was initially placed in the medical unit before transfer to solitary confinement in the J block some 6 days later. And then, being Bryan Kohberger on August 14th and his attorneys, they contacted prison officials regarding 2 brief video segments posted on Reddit, which appeared to show her client. In letters obtained through public records requests, Taylor's noted that the footage seemed to be captured by a guard from security cameras monitoring Kohberger's cell, expressing apprehension about his security. Anyway, Kohberger's legal team has refrained from granting interviews since the removal of the gag order in mid-July, invoking professional and legal duties to their client. Now, prison documents reveal that during his initial months in prison, Kohberger reported instances of mistreatment, including threats of sexual assault from fellow inmates. And as of Wednesday, he continues to be housed in the same prison section where these events occurred. Now, I just can't imagine that this would be that hard to figure out. We're talking a maximum security prison. You know who was working during a particular time period. You probably know who has access to those particular cameras. You think they would be able to figure something like this out. Apparently not. Apparently it is very, very complicated, and there's no way that they can figure this out. Or they know who did it and they're like, well, he's a good guy, whatever. We'll just let it go and hopefully it'll die and go away. And it probably will, and no one will ever care about it again. But do you also remember the court was very outraged and upset that there were leaks, allegedly from the prosecution, maybe the police, about information that was turned over to various news agencies. And there was going to be a big brouhaha. People were going to be prosecuted. And things were very serious. And this goes directly against the court's orders. Nothing. No comment whatsoever. And I'm not trying to cast dispersions on the police or the people investigating the case, but this is normally what happens when the government, believes that, well, although there was some misconduct, we don't really want to charge anybody because we like the people that did it, right? So they just kind of let it fade away, and they hope that nobody ever notices that nothing is ever done about it. And like I said, I'm not looking to get somebody in trouble, but once again, you mean to tell me you can't figure out who sent the information to the news? You can't figure out who videotaped the cameras of Bryan Kohberger in his cell? I just find that hard to believe. How many people could possibly have had access to those particular cameras? Well, probably people working in that particular cell block, right? Interview everybody. Just seems a little odd to me. Anyway, let's move on. Anyway, next on the docket, the suspected assassin of Charlie Kirk. He wanted a peaceful surrender. Why, you may ask? Because he had fears of, well, being shot. Yeah, could you imagine? That could ruin one's day, couldn't it? So let's get to it. The Washington County Sheriff, a guy by the name of Nate Brooksby, disclosed new details regarding the apprehension of Tyler Robinson, obviously the young man accused in the assassination of Charlie Kirk. Now, during a press conference on September 17th, Brooksby explains that Robinson sought a non-confrontational surrender, expressing concern about potential harm from law enforcement. Now, Brooksby recounted receiving a telephone call at about 8 p.m. on Thursday from a former colleague in law enforcement who identified Robinson as the perpetrator. The caller, connected to Robinson's family through some religious affiliations, indicated that efforts were underway to facilitate a voluntary surrender. Robinson reportedly experienced some suicidal tendencies, had been en route to a secluded area in Washington County, but was persuaded by his parents to abandon those plans and ultimately surrender. The family assured him of their support in arranging a safe turnover. Aware of the extensive media coverage featuring his image and the weapon involved, Robinson recognized the inevitability of his capture. He specifically requested assurances of a peaceful and gentle process to avoid escalation, such as a tactical teen raid or gunfire, conditions to which Brooksby consented to secure his compliance. Now, upon surrender, Robinson appeared subdued and reserved, and police refrained from immediate interrogation pending the arrival of the primary investigators. Brooksby advised Robinson's family and his partner, Lance Twigg, described as the transgender cohabitant for approximately 1 year, to maintain a low profile for an extended period without providing further specifics. Now, Twiggs has been relocated to a secure location distant from St. George, Utah, their shared residence, while external agencies interview his acquaintances. Now, the sheriff did clarify that a deputy in his department sharing the surname Robinson is completely unrelated to the suspect, urging media outlets to emphasize this distinction amid ongoing harassments directed at that particular officer. Now, a family member, speaking anonymously, attributed Robinson's actions to growing animosity towards conservatives and Christian ideologies, noting a process of radicalization that intensified over recent years, marked by increased detachment and anger. Now, obviously, Robinson faces multiple charges, including aggravated murder, 2 counts of obstruction of justice, felony discharge of a firearm resulting in serious injury, 2 counts of witness tampering, and committing a violent offense in the presence of a minor. Now, this incident occurred during Kirk's inaugural event for the American Comeback Tour at the Utah Valley University at the Losi Center in Orem, Utah on September 10th. Now, police allege that Robinson accessed the building's roof and fired a single rifle shot, striking Kirk in the neck. Kirk, known for promoting discourse on college campuses, was declared deceased shortly thereafter. Now, memorial tributes have accumulated at the hospital and the university campus, featuring messages of support, floral arrangements, and national symbols. So, I think it's always ironic when somebody has concerns, for example, of their safety, almost like Bryan Kohberger, who has concerns for his safety while he's in custody, but yet he didn't provide any safety or comfort or concern, compassion, to any of his victims. And now certainly Kohberger's doesn't get the presumption of innocence anymore, but Mr. Robinson does, unless and until he pleads guilty or is convicted by a jury of his peers. It's also interesting that the parents, along with the roommate, are in some sort of relocation area for their safety, but it also means that the government will more than likely be footing the bill for them to make sure that they remain safe, because they obviously want them to show up and appear at the trial. All right, next on the docket, Luigi Mangione. Supporters want jury nullification for his trial. So supporters for Luigi Mangione are advocating for jury nullification ahead of trial in the United Healthcare CEO assassination case. So fundraising and public backing, approximately 35,000 individuals have contributed more than $1.2 million to the legal defense fund for Luigi Mangione. Obviously, Mangione is the individual accused in the assassination of United Healthcare CEO Bryan Thompson. Now, Mangione, a former Ivy League student, maintains a substantial online following and draws crowds of demonstrators to his court proceedings. The campaign by his supporters for jury nullification, that's where jurors might render a verdict influenced by personal beliefs rather than strict adherence to the law, faces obviously some significant challenges to succeed. So, for those who aren't familiar with the case, Luigi Mangione is charged with the fatal shooting of Bryan Thompson, a father of two from Minnesota, which occurred outside of a shareholder meeting in New York City on December 4th of 2024. Now, police allege that Mangione maintained journals outlining his intentions for the assassination, including a desire to convey a critique of the health insurance sector. Let's keep in mind that jury nullification oftentimes will come up back in the 70s for draft dodgers, people that were prosecuted for not complying with the draft, and juries found them not guilty. You'd see that years ago for small marijuana cases. Juries would find somebody not guilty because they thought it was harmless. Anyway, obviously, this is a little different in the Mangione case because it isn't some sort of prohibition era violation or draft evasion. It is instead a deliberate, premeditated homicide / assassination where the CEO was shot in the back. So there's some concern regarding the district attorney's track record in prominent cases, particularly following recent dismissals of terrorism-related charges against Mangione. So a New York judge ruled on Tuesday that the terrorism charges lack sufficient foundation in the assassination case. Thereby, the judge dismissed them. Now, this decision eliminates the possibility of a first-degree murder conviction, which could have resulted in a life sentence without the possibility of parole. Now, Mangione continues to face a second-degree murder charge with a maximum penalty of life in prison, though he would be eligible for parole after an extended period of time in prison. Now, the crowds outside the courthouse expressed approval following the dismissal of the terrorism charges, obviously because they support Mangione. Supporters have highlighted Mangione's presumption of innocence under the law, which obviously he's entitled to. But in addition to jury nullification, New York law permits an extreme emotional disturbance defense, which could be employed to elicit juror sympathy and potentially mitigate the charges. Now, this approach would require Mangione's legal team to present compelling evidence during the trial. And if such evidence was in fact presented and a juror believed it, that, securing even a single sympathetic juror could lead to a potential mistrial. Obviously, this tactic is aligned with efforts to create a hung jury, though obviously the premeditated nature of the alleged crime would likely prompt repeated retrials by the prosecutor's office if there was a mistrial. And remember, the prosecution can keep trying as many times as they desire to get a conviction if there is in fact a mistrial. But remember, jurors will be screened during the voir dire process, whereby they're going to have to affirm that they intend to listen to the facts, follow the court's instructions, and follow the law that the court gives them. My experience is most jurors take their jobs very seriously, and they will indeed follow the law. But I assure you, there will probably be a lot of pretrial screening of potential jurors and any public posts or statements that they may have made about the Luigi Mangione trial, if any. And let's not forget, the federal authorities have separately raised alarms about Mangione's case potentially encouraging further acts of violence. In some pleadings filed back in August, prosecutors stated that segments of the public identifying as followers of Luigi Mangione are increasingly perceiving violence as a viable alternative to civil discourse in political matters. They specifically referenced a mass shooting incident on Park Avenue as an example of this trend. Jury nullification, ladies and gentlemen, it's always existed, but guess what? The defense cannot argue it. The defense cannot get up and say this killing was completely justified to make a greater political statement. And, he's just one guy in the big cog of insurance companies and no one's going to miss him. We're sorry about the wife and kids, but this is the much greater picture. The defense can't make that argument. Okay. They can't make the argument like, look at Luigi Mangione. Doesn't he look like a nice young kid, Ivy League educated, had everything. He looks great with his shirt off. I mean, ladies, take a look at that, right? No, the defense cannot argue that. So really what the defense has to do is go through the motions, go through the trial, obviously, and defend their client zealously, hoping that one of the jurors will pick up on the jury nullification hint that they will be trying to put out to the jury. We'll see if it works, if it ultimately gets to trial. Once again, the feds have this whole death penalty thing going on. And so, once again, there may be some sort of plea bargain to avoid the death penalty. Obviously, we'll have to wait and see. And if it happens, we'll bring it to you. Next, let's talk about that dead teenager found in a musician's car. Should we be suspicious? Anyway, police executed a search warrant at a residence in Hollywood Hills on the evening of September 10th of this year as part of an ongoing investigation into the death of a 15-year-old girl whose remains were discovered in a Tesla belonging to the musician David. Now, the remains, identified as those of Celeste Rivas from Lake Eleanor, were located on September 8th in the front storage compartment of an impounded Tesla at a tow facility in Los Angeles. The vehicle is registered to David, or D4VD, a Houston-based artist whose team has confirmed his full cooperation in the investigation. Now, the Tesla had been towed following reports of it being left unattended in the Hollywood Hills area for over a month. Investigators searched the home in question, though the specific link to the case remains undisclosed to the public. Now, discovery and identification of the decomposing body was detected by a tow yard employee due to a significant odor emanating from the car. Upon inspection, police found the remains contained within a bag in the Tesla's front trunk, commonly referred to as a frunk. Sources indicate the body was not fully intact either. Anyway, forensic analysis by the county medical examiner confirmed the identity of Celeste Rivas, who had been missing since April 5 of 2024 from the Lake Eleanor area in the western Riverside County area. Identification was aided by distinctive features, including a tattoo of the letters SH on her right index finger. The cause of death has not yet been established, and efforts to notify the next of kin delayed the public release of her name. Now, Rivas's family, residing in Lake Eleanor, has expressed profound grief. Her brother, Matthew Rivas, disclosed that Celeste was en route to join him for a movie outing on the day that she vanished but failed to arrive. He also noticed that the family was aware of her acquaintance with David. Now, the Los Angeles Police Department is handling the matter as a death investigation, obviously. And as of September 10th, no determination has been made regarding the manner or mode of death, and no suspects have been identified. Reports from external sources indicate that detectives removed items such as a computer and evidence bags from the searched residence. So what is this David guy's involvement? Well, David, or D4VD, whose legal name is David Burke, is a singer-songwriter who gained prominence through a viral content on TikTok, where he has about 3.6 million followers. This led to contracts with Darkroom and Interscope Records. Currently on a world tour that commenced August 5th, he has performances scheduled in various cities, including a show in Los Angeles on September 13th at the Greek Theater. His Seattle concert planned for September 10th was canceled, but a spokesperson reiterated his cooperation with police despite his tour commitments. Anyway, the investigation continues with no further details released on potential connections between the vehicle, the residence, and Miss Rivas's disappearance. That's weird. I mean, I wonder if this David guy reported that his car was stolen, missing. Did he even know? Maybe he was too busy on his world tour. Who knows? But it was his car, which obviously is a little concerning. And the fact that nobody happened to maybe report it stolen And the fact that you got a dismembered body in the trunk of a Tesla, well, that is obviously concerning as well. And apparently when you know the young lady, even if she's 15, well, that's kind of a problem as well, too. Now, certainly we're not saying that this David guy did anything wrong. The car could have been stolen. And frankly, he didn't know about it. We just don't know. But it certainly makes you go, Next on the docket, the Menendez brothers get a little more bad news. So a judge in California has denied the request for a new trial submitted by Eric and Lyle Menendez, who were convicted for the 1989 murders of their parents in Beverly Hills. Now, this ruling represents a further obstacle for the brothers, with Lyle Menendez publicly criticizing the decision as unsatisfactory. I know. Can you imagine his outrage? The righteous indignation is overwhelming. Anyway, on Monday, a Los Angeles Superior Court judge dismissed the habeas corpus petition filed in 2023 by the brothers' legal representatives, Cliff Gardner and Mark Garagos, as reported by the local media. Well, the petition contended that newly presented evidence substantiated the brothers' assertion of prolonged sexual abuse by their father, Jose Menendez. Now, the legal team highlighted a letter purportedly authored by Eric Menendez to his cousin Andy Cano around the time period of late 1988 or early 1989, as well as recent claims from Roy Rosello, a former member of the musical group Menudo, alleging abuse by Jose Menendez during his adolescence. Now, in their submission, the attorneys argued that this evidence demonstrated Jose Menendez's violent and abusive behavior towards children and indicated ongoing abuse of Eric Menendez in December of 1988, aligning with the defense's longstanding position. Nevertheless, the Judge William Ryan, concurred with the prosecution's view, concluding that the evidence was unlikely to alter the verdict in a jury trial. Remember, ladies and gentlemen, when you do post-conviction or a habeas petition, you have to show, one, like that the attorney was ineffective or that this is new information, but it would actually have changed the result. So the judge says, yeah, it's interesting, but it's not like you're going to be able to use that as a defense. That's mitigation, right? We talk about that. Defense, mitigation. Defense is you're excused under the law. Mitigation helps to reduce the sentence. Anyway, in a social media statement, because, when you're in prison, you got to keep your social media presence up, Lyle Menendez voiced his dissatisfaction with the outcome while affirming their commitment to pursue further action. I guess he can appeal the denial of the habeas petition, but that's kind of about it. He stated that the ruling overlooked the significance of Rosello's testimony and Eric's letter, describing the judicial assessment as an implausible dismissal of their potential impact on jurors. Professional point, probably don't criticize the judge that, holds your fate in his hands. Anyway, during a press conference on Tuesday, the district attorney, Nathan Hochman, supported the judge's determination, asserting that the evidence did not satisfy the criteria for granting a new trial. He noted that the letter from Eric was not novel, having existed for decades without prior introduction in court, and questions its timeliness under habeas corpus guidelines, which typically require filings within 5 years of evidence discovery. The development follows the denial of parole for both brothers last month in connection with the killing of Jose and Kitty Menendez. Now convicted back in 1996 at the age of 18 and 21, the brothers received initial life sentences without parole. After a comprehensive review, the California Board of Parole Hearings rejected Lyle Menendez's parole for 3 years, referencing patterns of deceptive behavior and rules violation. Similarly, Eric Menendez, his parole was denied, with the board citing the gravity of the offenses and his institutional record as a reason for deeming him a continued risk to public safety. The recent parole denials come after a resentencing in May, where the judge adjusted their sentence to 50 years to life, rendering them eligible for parole evaluation. Both brothers may seek reconsideration in 2028, and representatives from the district attorney's office and the Menendez brothers' legal team have not provided immediate responses to any further inquiries regarding the denial of the habeas petition. Their best shot, obviously, was when their sentence was resubmitted and they were eligible for parole. The last 30 plus years of confinement, they have been bad boys on the inside. And normally you get your good time, your earned time. Sometimes it can be eliminated, right? So instead of serving a 30-day sentence, you get 18 days of credit. So you'd serve 18 on 30, for example. And obviously that accumulates over the years, right? But if you don't play well with others, even when you're in custody, the prisons can take away your good time. The Menendez brothers more than likely thought, hey, I'm here for the rest of my life. Screw it. What are they going to do? Send me to prison for the rest of my life? Well, now they're showing that it's a good example of why you should behave even in prison. Good behavior is rewarded in prison. Bad behavior is punished even in prison. It's kind of like life. You follow the rules, good things happen. Don't follow the rules, bad things are supposed to happen. You don't follow the rules more and more that you don't follow them, the more bad things are supposed to happen. Menendez brothers are learning their lesson, although I'm sure they will deny it, blame it on their parents and on the judge. Next, take a look at this teacher's reaction when she is being arrested. Can you believe it? So, in a performance that wouldn't fool a kindergartner, body cam footage reveals a disgraced educator's ham-fisted attempt at innocence when the law came knocking for her heinous act against, wait for it, an 11-year-old student. Please meet Allie Barfield. She is a 34-year-old teacher. That's right, 34-year-old stand-in instructor from Decatur Public Schools. Anyway, confessed to enticing her middle school charge to her Mount Zion, Illinois abode under the guise of innocent hangouts, only to perpetrate sexual violations. Now, the predatory plot began to crumble back in April of 2024 when the boy's vigilant mom spotted his unusual behavior post a suspicious overnight at Barfield's place from March 29th to the 30th. A quick dive into his devices unearthed a nauseating proof of a twisted liaison. The youngster revealed swapping explicit images via Snapchat and pocketing over $700 from his abusers across several months. He also detailed unprotected encounters on her marital mattress, shared with her builder spouse, Casey Newton Barfield. Now, the alarmed parents rushed him to the hospital for forensic examination, though the Barfield dropped the charade and owned up in August. Newly surfaced arrest video from last year showcase her channeling a bad soap opera star upon initial confrontation. Days earlier, the victim and the kin had tipped off police about the exploitation. And then in April of last year, as cops rolled up, Barfield emerged casually, noting 3 kids inside. You're under arrest, an officer declared, armed with a search warrant. Me? She gasped, clutching her chest like a damsel in a dime store novel, clad in a glaring red Mount Zion hoodie. Yep, your alley, correct? The cop deadpanned, unmoved by the theatrics. Post-identity check, he spelled out the charges: predatory sexual assault and child grooming. For what? She squeaked, feigning bewilderment. Plenty of damning proof, he countered. Met with her swift denials, she shuffled to the squad car, arms folded in reluctant defeat. Anyway, court filings disclosed that earlier guardians and police eavesdropped on her chats with the boy, where she bantered about contraception, fertility, fables, and text erasing tips. She claimed infertility and eagerly agreed to repeat rendezvous if he visited. These claims stun, particularly from a trusted figure. The Mount Zion police noted dryly in their release, "We're dedicated to supporting survivors and families through such ordeals." And of course, the Decatur school swiftly fired Miss Barfield once this scandal broke, and she copped a plea 16 months on in the process. The boy's relatives intend to litigate against the district for oversight lapses, and the offense carries a potential 60-year stretch, but a deal guess what? She can't get more than 40 years. That date will come on September 25th. So I'm not really sure where that fits in. A 39-year-old woman with an 11-year-old boy. Ew, gross. Seriously? Are you kidding me? 40 years, I think, is going to be the more appropriate sentence. Just do not get it, ladies and gentlemen. Do not get it. And that is getting into the range, right? Remember, the legal definition for is somebody is prepubescent. 11-year-old boy, probably prepubescent. All right, next on the docket. There's been a lot of talk about the First Amendment. Everybody seems to be an expert these days on the First Amendment. And for the most part, well, most people are wrong. So I thought I'd take a moment to try to explain it to you. And I think we got it all right. And guess what? If you repeat this, your friends are going to think that you are so smart. All right? So let's quickly talk about the First Amendment. And that's the First Amendment to the United States Constitution, which states, Congress shall make no law respecting an establishment of religion or prohibiting the free speech exercise thereof, or abridging the freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for redress of grievances. Now, this was ratified in 1791 as part of the Bill of Rights, and it primarily safeguards individual liberties against government interference. Now, this applies to everybody in the states through the 14th Amendment incorporation doctrine that established back in 1925 in Gitlow v. New York that these protections extend to state and local governments. Now, the amendment's speech clause promotes open discourse, democratic participation, and self-expression, but it is not absolute and excludes certain categories of unprotected speech. So let's be very clear. The First Amendment only prohibits the government from arresting individuals solely for exercising protected speech, as this constitutes unlawful censorship or retaliation. Government actions, including arrests, must not fringe on expressing freedoms unless the speech falls into a unprotected category. For instance, arrest motivated by retaliation for protected expression violates the amendment, even if probable cause exists for other reasons, providing plaintiff can demonstrate retaliatory intent through objective evidence. Now, let's take a look. There's a case, Nieves v. Bartlett, a 2019 case, held that claims of retaliatory arrest for protected speech generally fail if probable cause exists, but exceptions apply for uncommon offenses where discretion is high. Then we've got Gonzalez v. Trevino, a 2024 case, ruled that arrests in retaliation for protected speech infringe on First Amendment rights, allowing the plaintiff to proceed without comparative evidence if objective proof of retaliation is shown. And then we got the Lozman v. the City of Rivera Beach in 2018, clarified that official policies of retaliation against protected free speech violate the First Amendment regardless of probable cause. So the First Amendment constrains only government, the state actions, and does not regulate private disputes or civil litigation between individuals or entities. So private actors, such as employers or social media platforms, may restrict speech without violating the First Amendment, as it lacks a state action requirement in such context. All right. Now, it's different if the state, for example, calls up X or Twitter like they did and said, take down this guy's content because we don't like it. That would be a First Amendment violation. But if it's just a private company regulating their content, what they believe is appropriate, that's okay. So when the courts enforce civil laws implicating speech, they may apply First Amendment scrutiny to ensure that the government involvement does not unduly burden expression. All right. So where do we go from here? Let's take a look at Manhattan Community Access Corporation v. Halleck in 2019. It affirmed that the First Amendment does not apply to private entities operating public access channels, as they are not state actors. Then you can go to Rendell Baker v. Cohn, a 1982 case, and it determined that private schools receiving public funds are not state actors, so First Amendment claims there fail as well. And then we got Hudkins v. the NLRB, a 1976 case that ruled that private shopping centers, the owners can restrict speech on their property without First Amendment implications. Well, let's talk about defamation and libel. So individuals may face civil liability for false statements through defamation, the spoken word, or a libel through the written word. Anyway, these lawsuits, as the First Amendment does not shield harmful falsehoods. However, to balance reputational protection with free expression, plaintiffs must meet heightened standards, particularly if the person is a public figure. Private parties can sue for damages without government involvement, triggering direct First Amendment violations, though courts incorporate constitutional limits to prevent the chilling effect of speech. So that takes us back to the Supreme Court case of New York Times versus Sullivan, and that established the actual malice standard for public officials suing for defamation. And it requires proof that false statements were made with knowledge of falsity or reckless disregard for the truth. Then we got Gertz v. Roberts Welch, Inc., a 1974 case that extended protections to private figures, allowing states to set liability standards short of strict liability, but requiring proof of fault. And that limited punitive damages absent actual malice. Then let's not forget the Milkovich v. Lorraine Journal case, a 1990 case. It clarified that opinions implying false facts can be defamatory. So if you want to say, in my opinion, somebody is blank, implying false facts, you can be held liable as well. But pure opinions remain protected. All right. Next, true threats, which we've talked about lots and lots on this channel as it relates to not protected speech. Now, true threats are statements conveying intent to commit unlawful violence against a specific individual. They're not protected by the First Amendment, allowing government prosecution for that. Now, the standard requires proving the speaker's recklessness regarding the threatening nature of the speech, distinguishing it from hyperbole or just jest. This exception prevents intimidation while preserving robust debate. Then we have the Supreme Court case of Watts v. United States, a 1969 case that held that a statement about shooting the president was political hyperbole, not a true threat, emphasizing context in the assessment. But then we got Virginia v. Black, a 2003 case that ruled that cross-burning with intent to intimidate is in fact a true threat, unprotected by the First Amendment. Then we got Counterman v. Colorado here in the United States, which I'm familiar with, required the government to show reckless, conscious disregard of risk in true threat prosecutions to comply with First Amendment limitations. Anyway, speech advocating violence or lawlessness is not protected if it incites or produces imminent lawless action and is likely to do so. Anyway, this narrow exception, refined from earlier clear and present danger tests, ensures abstract advocacy remains safeguarded while targeting direct calls for immediate harm. And then let's not forget the 1969 Brandenburg v. Ohio case, and it overturned the conviction for a Ku Klux Klan advocacy, establishing that speech is unprotected only if directed at inciting imminent lawlessness actions and likely to actually produce it. How about Shrink v. United States? Introduced the clear and present danger test, upholding convictions for anti-draft leaflets during wartime, though later narrowed throughout the years. And then we got Hess v. Indiana, where it protected a protester statements are as not inciting imminent action, reinforcing Brandenburg's imminence requirements. So hopefully that makes sense, ladies and gentlemen. Remember, First Amendment protection requires government action. Okay? You still can't threaten or harm people. And yes, you can be held responsible for that. Now, I'm a free speech purist. I really am. I've said this before. Free speech is good. We get to find out what people's opinions are, right? Like I said, if I wanted to hire somebody and I did a search of their social media presence and I found out that they were a flat earther, well, I probably wouldn't hire them because I would think, well, they're not too bright. And so there's consequences to you putting your opinions out there. You can essentially not have a future if people think you're not bright enough to hire because you think the earth is flat, by way of example. So there you go. You can say whatever you want, but you got to be aware of the consequences. It's not, yes, you can say pretty much whatever you want and the government's not going to come for you, but the community may. So you got to be careful of what you say. And as most of your mothers probably told you, if you can't say something nice, just don't say anything at all. Next on the docket, this day in legal history, September 18th, 1850. President Millard Fillmore signed the Fugitive Slave Act of 1850, obligating law enforcement to arrest escaped slaves in all U.S. states, including those where slavery was not legal. Free black men and women were endangered by the act's passage as they were at risk of being falsely identified as escaped slaves. Obviously, the act heightened tension between abolitionists in the North and slaveholders in the South, contributing to what would become the Civil War 11 years later. On this day in 1947, the Central Intelligence Agency officially comes into existence under the National Security Act, shaping intelligence law and foreign policy. On September 18th, 1975, Patty Hearst is captured by the FBI, leading to a landmark trial on kidnapping, bank robbery, and the legal recognition of the Stockholm Syndrome. Then on this date in 2020, Ruth Bader Ginsburg, the Associate Justice of the United States Supreme Court, passes away. Our legal quote of the day, figure might as well keep a free speech theme going on. Free speech carries with it some freedom to listen. Warren E. Burger and the Richmond newspaper v. Virginia case, a 1980 decision. And finally, our dumb criminal of the day, ladies and gentlemen. Step right up and witness the crowning of today's dumb criminal of the day. Our winner, a Massachusetts commuter with a temper shorter than a rush hour bus ride. Well, he has clinched the title with a performance so outrageous it practically is Oscar worthy for idiocy. Here we go. On September 8th, and the scene is a Massachusetts Bay Transportation Authority bus in Roxbury, where our champion of poor choices decided to make her mark on what a cinematic gem captures this genius in action, standing behind an elderly woman at the front of the bus. Doors open, baby strollers parked nearby, like props in the absurd drama. The suspect, in a mood fouler than a delayed subway, is barking at the elderly woman to get off the bus. Why? Apparently, the senior citizen had the audacity to be disrespectful while our winner was just trying to get to work. The nerve! Then, in a move that would make a soap opera villain blush, our hero shoves the elderly woman with the force of a linebacker, sending her tumbling onto the pavement outside. The crowd gasps, the stroller stays silent, and our star flees the scene faster than you can say bad life choices. But here's the kicker. The long arm of the law wasn't far behind. Police tracked down this shining example of humanity and slapped cuffs on her quicker than you can say bus pass revoked. The victim thankfully walked away with non-life-threatening injuries and was whisked to the hospital for some precautionary checkups, alert, and probably wondering what she did to deserve a starring role in this fiasco. Well, the bus people, ever the voice of reason, reminded everyone that their drivers are trained to call first responders and not play hero unless it's life or death, because common sense isn't as common as we'd hope. So here's to our dumb criminal of the day who turned a routine bus ride into a viral spectacle of stupidity. Please take a bow, not just on a moving bus, please. That's all we have for today, ladies and gentlemen. Hope you enjoyed the show. Thanks for watching. We'll see you next time. And always remember and never forget, the Constitution matters.